Hey, how you doing? This is Adam Post. According to the Hollywood Reporter, Disney's getting sued for $10 billion. $10 billion is a lot of money. Why would someone sue them for something like that? Well, because according to this lawsuit, and we'll get into the lawsuit, they stole Moana from another animator who was trying to pitch not exactly Moana, but something similar to Moana to get made as its own animated film. Would Disney do something like this? Even Disney doesn't know if Disney would do something like this because when they get pitched things, they get things from a lot of sources. They have a lot of conversations, all kinds of things go into development. People join the company, people leave the company. They get millions of submissions from all over the place. Even when they try to separate things and say, okay, well, we don't want to look at this because we might get sued if what you submit is similar to that. A lot of that does go on. At the same time, there are some people who might not be 100% honest, and if they see an idea and they know the source of the idea and they're trying to come up with something, they might look at it. And that might not be even a Disney employee. It could be an outside producer. It's difficult to know, like, what's the whole history of how something gets produced. Disney did keep records on how pitches and ideas and even going on trips and doing travel inspired the creation of Moana. At the same time, this animator actually does have a pretty good argument he's making here. He did have a complete script, he did have his ideas detailed out, and there are a lot of similarities between Moana and his original property. And this is not the first time that this creator tried to sue Disney over Moana. In a very similar lawsuit, he sued them after the first Moana came out. The judge ultimately said, well, you didn't sue soon enough. And it does make you wonder a little bit, if it's theft, if it's not someone else's property, why does it matter how long I wait to sue you? Well, there's a statute of limitations. They have a way of doing things. They got away with it. Let's put it that way. It was not resolved. But the judge did say that if he had sued sooner, he would have let the guy proceed. Since then, Disney put out Moana 2, which has done almost $1 billion now. It's a huge moneymaker for Disney. It may hit $1 billion. It may not hit $1 billion worldwide. Either way, it's made a lot of money, and this creator is pretty upset because there really are some pretty specific, stark similarities that you would say, yeah, somebody at some point took something from his work and put it into Moana. It kind of looks like it. You can't tell until you go through the whole trial and look at all the evidence and the explanations, but it does look like this guy might have a case, and he's going to get a chance to make his case. Coming from the Hollywood Reporter, Moana 2 sparks copyright lawsuit as animator revives idea theft claims. Buck Woodall claims awards contender stole ideas from a screenplay he wrote, while Disney says the works are not similar. With a little more than a week left before the Academy Awards nominations are set to be announced, Disney has been sued for allegedly copying the idea for Moana and its sequel. Animator Buck Woodall, in a lawsuit filed on Friday in California federal court, claims Disney ripped off elements of a screenplay he wrote for an animated film called Bucky. Both works, which are set against the backdrop of an ancient Polynesian village, follow teenagers who defy their parents by embarking on a dangerous voyage to save their homes while encountering spirits manifested as animals along the way. That is a relatively close similarity. But that's not really enough to prove copyright infringement. But wait, there's more. The filing of Friday's lawsuit follows a court ruling in November that Disney doesn't have to face an identical copyright lawsuit brought by him over Moana because he sued too late. The release of Moana 2 allowed him to initiate further legal action. And why would the release of Moana 2 give this guy a right to sue Disney all over again? Because it reset the time limit on the statute of limitations, the limitation of how long you have to sue if you've got a copyright complaint. In his first case, the court found that a jury should decide whether the works at issue are substantially similar if the statute of limitations had not passed. It also concluded that an individual at Disney Animation TV may have seen copyrighted materials for Bucky, that's the animator's similar project, prior to the beginning of development for Moana, which was released in 2016. Quote, there is a disputed issue of genuine fact regarding substantial similarity and striking similarity between the parties' works, wrote U.S. District Judge Consuelo Marshall in the order. Moana 2, which may garner an Academy Award nomination for Best Animated Feature, debuted at $224 million at the box office, smashing numerous records on its way to the biggest 5-day opening in history. The original grossed at least $687 million worldwide. Starting in 2003, Woodall says he provided the screenplay and a trailer for Bucky, that's his project, to former Mandeville Films director for development Jenny Marchick, now DreamWorks Animation's head of development for features. She allegedly asked about providing further materials, including character designs, production plans, and storyboards, by assuring him she could greenlight the film. And if you're that animator, when someone who's the head of DreamWorks Animation or any major studio is telling you, hey, I can greenlight this film, I can get this film made, I just need to see a little bit more from you and I'll get that movie done. I'm sure the animator was pretty excited about that and never expected this to happen. At the time, Mandeville had a first look deal with Disney and had offices on its facilities in Burbank, according to the complaint. In a first look deal for a Hollywood production, this means you've agreed as someone who produces material to show that material first to that studio. So you're not going to go shop it all around town. You're going to put as many ideas as you get together that you think you might be able to do and get funded and show them to whoever you have a first look deal with. Sometimes a first look deal also includes payments of cash to fund your development, because if you're a producer and you're putting projects together, why should you give all of your stuff to Disney? Or why should you give all of your projects to Paramount? Well, because they may be paying your costs for developing and finding or acquiring that material, as well as providing you with free office space, as well as providing you with additional cash. It just depends on the deal. But a first look deal can be very good for both parties. In this case, it didn't work out so well for the guy who's suing Disney. The lawsuit points to similarities between Moana and Bucky. One example, both celebrate a recurring theme of the Polynesian belief in spiritual ancestors manifested as animals. Other similarities include the protagonist's journey, starting with a turtle, a plot involving a symbolic necklace, a main character who encounters a demigod adorned with a giant hook and tattoos, and a giant creature that's concealed within a mountain. That is kind of a lot of similarities. Quote, Disney's Moana was produced in the wake of Woodall's delivery to the defendants of virtually all constituent parts necessary for its development and production after more than 17 years of inspiration and work on his animated film project, according to his lawsuit. Also at issue are alleged overlaps between Bucky and Moana 2. Both works, for instance, feature the protagonist searching for an ancient island and undertaking a mission to break the curse. Quote, Moana and her crew are sucked into a perilous whirlpool-like oceanic portal, another dramatic and unique device imagery found in plaintiff's materials that could not possibly have been developed by chance or without malicious intentions. Malicious intention is deliberately doing something that you know is wrong. You know you're copying this from this guy's material. That's his allegation. Woodall, the plaintiff, seeks damages equivalent to 2.5% of Moana's gross revenue, or $10 billion, as well as a court order barring further infringement of his copyrights. How do you get to $10 billion from 2.5%? Moana did not generate anywhere near $40 billion, but this isn't even $40 billion. 2.5%, with $10 billion being a share of the total revenue created, would be $400 billion. So it could be that the Hollywood Reporter got the numbers wrong. Maybe it's in the lawsuit. We'll check out the lawsuit in just a minute. On summary judgment in the other lawsuit brought by Woodall, Disney contested allegations that the works are similar and that no one involved in the creation of Moana saw Woodall's materials. Quote, Moana was not inspired by or based in any way on Woodall or his Bucky project, which I learned of for the first time after this lawsuit was filed, according to director Ron Clements in a declaration to the court. To support arguments that it created the movie on its own, Disney also submitted documents regarding the origin and development of Moana, including story ideas, pitch materials, written research, travel journals, and scripts. The screenplay for Bucky has been registered with the Writers Guild of America, with the U.S. Copyright Office granting protection to the material. So it's not like the guy's not to be taken seriously. He did get close the first time he sued Disney. Now he's suing them again, and his Script really is registered with the Copyright Office and the Writers Guild, so he's going to have a serious case here. It's likely Disney looks at this, talks to the guy, and says, okay, we're not going to give you $10 billion gazillion, but why don't we talk about a number that both of us would be happy with? Regardless of how strong the case is, I think it's really likely they settle. But let's see the lawsuit. It's Buck Woodall versus Disney and a bunch of Disney subsidiaries. Disney has multiple different companies that they operate through to do various things that interact with each other. This is not really completely unusual. It's kind of a normal thing to do because the different entities do serve different purposes, whether it's holding rights or for production purposes or financing purposes and separating those companies. Ultimately, Disney owns all those companies, but they have accounting reasons and legal reasons. The plaintiff is suing them for copyright infringement, continuing copyright infringement, willful copyright infringement, and is looking for injunctive relief for willful and continuing copyright infringement. As you can see, it's about copyright infringement. The plaintiff here is claiming that Disney is creating companies to hide evidence and to hide the history of the creation of materials. That's a pretty big stretch. Part of that is also going to be getting jurisdiction over all of the entities rather than limited entities. I think for the purposes of the copyright lawsuit, he's not going to have a problem suing Disney, whether or not the court agrees that they created these entities to hide ownership and hide the proof of ownership of creating Moana and the Moana characters, particularly because I'm sure they do this with all of their entities and a lot of their production. If they did create all these separate companies and hid the development here and hid the development over there and the financing over here, and all of this was just for Moana, maybe, but even so, I don't think it has a big impact on the claim. The plaintiff has a lot to say about Disney using these different companies and the different names of the companies to hide emails and evidence that would show that he was the creator of the Moana story. He says this: during the engagement in the wrongful conduct alleged in this complaint, each of the defendants, that's all of Disney's companies and the private people, individuals involved in this, acted in concert with one another, intentionally orchestrating and executing a calculated scheme designed to defraud, injure, and irreparably harm the plaintiff. The defendants, acting as co-conspirators and joint venturers, participated in a fraudulent enterprise that encompassed the theft, misappropriation, and extensive exploitation of the plaintiff's copyrighted materials, intellectual property, and trade secrets as set forth in the complaint. This conspiracy was marked by a web of coordinated actions, including but not limited to deliberate misrepresentations to deceive the plaintiff, systematic concealment of critical evidence, covert meetings to plan their infringing activities, and the distribution of stolen materials across various platforms, thereby maximizing their illicit profits at the plaintiff's expense. Disney's conspiracy extended to publishing a new infringing motion picture right under this court's jurisdiction, while intentionally disregarding and actively violating this court's orders, compelling the disclosure of relevant documentation and information, including that associated with Moana 2. In furtherance of their scheme, the defendants not only failed to produce the mandated evidence as ordered by this court, but also engaged in efforts to secrete, destroy, or alter incriminating documents and digital files to further secrete the evidence. These acts were undertaken with the singular purpose of obstructing justice and evading accountability. And all of this while reaping billions of dollars in unlawful profits, and none of which could have been achieved without the carefully planned conspiracy alleged herein, as well as the carefully implemented domination and control by the Walt Disney Company over the entire process through its alter ego control over the Disney entities. So he's alleging a conspiracy here. He may have more and more documentation for it. I don't know if he's going to go ahead and prove a conspiracy or just show how his material is similar to their material. The accusation here also is that in addition to infringing on his copyrights, Disney also went through a kind of scheme to try to hide the evidence showing that they did know that they were infringing on his copyrights. And here's where it gets a little bit interesting. In the first time around when he sued Disney consistently, according to the plaintiff, in writing on innumerable occasions and in filings before the court, refused to produce any documents or information of any kind other than documents or information possessed by Walt Disney Animation Studios. This court repeatedly ordered the defendants and each of them to produce all responsive documents, which included all information and materials regarding the character Moana. This court refused to hold the defendants accountable in any way, shape, or form, and permitted the defendants to only conduct a full search with respect to the archives of Walt Disney Animation Studios for documents. This court made such rulings on numerous occasions so repetitive as to be significant in the context of any litigation, far more than simply a couple of court orders. Despite protecting the defendant's stated desire to not search for documents, however, this court was unable at summary judgment to make any ruling other than that the issues of substantial similarity, striking similarity, and access must go to the jury because they presented triable issues of fact as a matter of law. Well, at least according to this lawsuit, and we didn't cover the first lawsuit, it does appear that Disney did refuse to search all of their entities' research and information and files and records and documents and provide them for the lawsuit. And the court went along with that. It may be because of the statute of limitations issue. Because if the original lawsuit for Moana was outside the legal time allowed that you could bring a lawsuit claiming copyright infringement outside of the statute of limitations, that would explain why the judge would say, look, I'm not going to force them to provide a lot of additional information from all sorts of entities and go through a lot of process here if you're outside of the statute of limitations. You just kind of lose. You can't do anything about it. Sorry about that, Mr. Plaintiff. But now they can. Okay, let's see what the animator wants from Disney. This is where a plaintiff is detailing out what they're looking for in their lawsuit. A, for a declaration that defendants have infringed plaintiff's copyrighted materials pursuant to all causes of action. B, for an award to plaintiff of compensatory damages against all defendants in an amount exceeding 2.5% of the gross revenues derived from Moana in the sum of at least $5 billion under the first, second, and third causes of action. D, for an accounting of all revenues of any kind generated by the defendants from each portion of the Moana franchise following the theatrical release of Moana 1, or alternatively for an accounting of all profits generated from, after, or by reason of the theatrical release of Moana 2. E, for statutory damages and willful infringement under 17 U.S.C. 504C, including enhanced compensatory damages for the defendant's willful conduct in a sum exceeding $10 billion pursuant to the third cause of action. And the plaintiff is demanding a jury trial. If you're Disney, you're getting sued all the time in every possible conceivable way. This copyright lawsuit looks like it has the potential to go a little far enough that Disney's going to have to write this guy some kind of check. Even if the judge doesn't love this lawsuit, the judge is likely going to let this lawsuit move forward, and if it picks up where the last lawsuit left off, and it looks reasonable that it would, the current judge is going to ask Disney to provide all kinds of documents that it looks like Disney doesn't actually want to provide with respect to the creation of Moana and Moana 2. This is why big companies spend a lot of money on lawyers. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.